In this video, I'm going to cover the three main estate planning documents that you want to have in place. Hi, my name is Zach Morris with Paces Ferry Wealth Advisors, and I once had a mentor tell me that you can handle 80% of your estate planning with 20% of the effort. And what he was referring to is really three main documents. There's your will, there's your power of attorney, and your healthcare directives. So having those three documents in place really takes a lot less time than people think it might take. And most attorneys offer this in a single package. So first, let's talk about why you should update your estate plan, right? Why should you go through the effort of updating these documents? You already have them in place, maybe. You did them 10, 15, 20 years ago, right? And the reason why is that laws change, technology changes, software changes. There's a lot of reason, and also you change, right? So you might have gotten divorced. The composition of your investment portfolio or the composition of your family might have changed, right? You might have moved states. You might have had grandchildren. There's a lot of different things that could have happened that could trigger the need to update your estate plan. But typically, we say that you should update your estate plan every 5 years. Now, let me give you an example of something that might have changed in the law. Many of these estate attorneys use software to write the will. They use software to write the power of attorney. A lot of these are based on current law, right? If a software was used 10 years ago, 15 years ago, maybe the law has changed, right? So maybe language that was put into a will 20 years ago has been challenged, right? And attorneys decided maybe that's not the best way to say it. Maybe there's a better way to say it so that this wish isn't challenged in court or in by potential beneficiaries of the will, right? So there's a lot of things that could have happened in the last 5, 10, 15, 25 years that would lead to a good reason to update your estate plan. So the first thing I want to talk to you about is a will. A will is a document that allows you to take inventory of all of your assets and decide who will get them when you die. It also allows you to name an executor of your will. So that's the individual or individuals that will carry out the wishes of your will. Now, many times people want to list multiple people as executors on their will. And what estate attorneys have told me in the past is that this can create difficulties in probate because more than one person has to go to the probate court. More than one person has to raise their right hand and say that they're going to carry out the wishes to, the best of their fiduciary ability. And many times they might have to sign documents. So multiple executors would have to sign multiple documents. If you have children under the age of 18 and you've been waiting to decide when to do your wills, it's important to note that the will allows you to name a guardian for your children. So if something happens to both parents at the same time, the will allow you to name who will take care of your children in the event that you die. So one thing to keep in mind when you're naming a guardian for your children is that you want to name an individual and not an individual and their spouse. So for using the example of your sibling, you don't want to name your sibling and their spouse. You just want to name your sibling because in the event that they're separated at the time of your passing, right, you don't want there to be any confusion as to who you wanted your children to go to. The next document that you want to have in place is called a power of attorney. So a proper power of attorney will assign somebody the ability to carry out your affairs in the event you're incapacitated. So you don't want to come out of a 3-month coma and realize that your tax returns have never been signed because nobody could legally sign on your behalf. Now, some financial institutions actually have their own power of attorneys. And so if you have, or your elder parent, let's say, has an account at a financial institution, it may be a good idea to look into seeing if they have their financial power of attorney, which would allow you to control those accounts on their behalf, rather than trying to use your own power of attorney. The next document that it's important to have in place is something called advanced medical directives. So there's two types of advanced medical directives. One is a healthcare proxy, and the other is a living will. A living will is a document that allows you to provide guidance to loved ones and healthcare providers and may allow you to provide guidance in terms of your medical treatment in various circumstances. This may include whether you want a feeding tube or general life support. Now, a healthcare proxy is somebody that you name to make healthcare decisions on your behalf in the event you're incapacitated. So it's not possible for a living will to outline every possible scenario that could ever arise. For example, if there are 3 different medical trials that can be used to potentially save your life, right? You didn't know that those medical trials existed at the time that you wrote your living will. So it's important to have a healthcare proxy in order to be able to help make those decisions for you. Now, oftentimes, I have people say, "I don't need a living will. I have a healthcare proxy," or "I have so and so. I have my spouse," right? And what I often tell people, and I've been advised by estate attorneys, is that oftentimes in those situations, it's helpful to have a living will because then it takes the onus off of your loved ones to make that decision for you, right? If you have in your document that you don't want to be on life support or you don't want to have a feeding tube or other type of life-saving measures, if that's important to you and based on your preferences and values, right? Then you take that burden off of your loved ones to make that decision on your behalf, right? You've already made it for you, and the healthcare providers can communicate that to them that this isn't your decision. This is theirs. I hope this video was helpful for you today and you learned something. If you did, please give it the thumbs up and subscribe below. And please be on the lookout for more videos from this channel. Thank you.